December 16th.
Yes, and if it's muted.
So TV's right.
All right, welcome to the 294th District Court. My name is Judge Chris Martin. I'm going to call this morning's docket. When I call your name, please say present or here and raise your hand. All right, I may not look up, I may be listening, so just do both for me. And then counsel, after I call the docket, anyone that has anything agreed, if y'all all kind of form a line over here, I'll know who's first and we'll start calling your cases. Pedro Cespedes. Pedro Cespedes. That one may be on me. Michelle Daly. Jennifer Gonzalez. Rebecca Hunter. James Johnson II. Kendall Miller. Lenel Perez. Leonel. Lenel Perez. Leonardo Rosas. Leonardo Rosas. Jason Bearden. Hector Hernandez. Leighton Hausch. Tayamika Johnson. Vicky Lovern. Billy Schultz. Teresa Villanueva. Laura Fleming. Laura Joy Fleming. Lauren Foley. Grace Fowler. Cody White. Cody D. White.
Judge, I heard them say he is here, but he's outside with like symptoms.
Is he here or is he not
He's
here?
here outside.
Outside? Okay. Okay. Kendrick Willis. Kendrick Willis. For the record, Adrian Serta, CR 21381, waiver of arraignment filed and granted, pretrial set March 10th. Sid Hoffpower. Did I say that right?
Yes.
Really?
Very good.
Okay, well, I was betting against myself on that one. Xavier Rojas. Hannah Hodge. Tylea Powell. Joseph Simpkins. Carlos Padron. Shelby Newton. Shelby Newton. For the record, Joel Rodriguez Garcia, CR 21390, waiver of arraignment filed, granted, pretrial set February 22nd. Ashley Smith. New Law. New Law. Yes, ma'am.
site, don't you? I don't believe so.
All right, for the record, state has tendered a motion to dismiss in CR 21-315 new law. Court has granted. Sign the order. For the record, CR 21-303 Chiquita Peoples. Case was dismissed. Court signed on January 13th. Richard Sutton. For the record, Violet Ward, CR 21-313, case dismissed, signed January 13th. Noemi Esquivel. Richard Morrison. Joshua Flores. Joshua Christopher Flores. William Robertson. Keith Thomas. Keith Thomas. Do have a notation that the defendant is claiming positive test for COVID, but Mr. Todd is supposed to be getting us some documentation. Mr. Todd's not here at this time. Kiana Walker. Marcus Ellison. Motion for continuance filed, granted. Docket call reset to February 22nd. Robert Schultz. Aaron White. Shanna Dixon, CR 21-383, waiver of arraignment filed, granted, pretrial set February 22nd. Willie Jopling. Jordan Manis. Lance Robertson.
Under less than half of it is Dallas County. I talked to his attorney in Dallas. Apparently he had funded out there. He's on a QR on here, so. I'll get in touch with you since he's funded out.
Thank you, sir. Lance Allen Robertson. All right. Which one? Willie Jobling, CR 25-2.
Your Honor, it's my understanding we're set for PTI compliance. I've got some stuff I'm gonna need to give over to the state on this, but I guess we can just move it to docket call. And we'll make an announcement there if we need a bench trial, if we're gonna work it out.
No pressure from the state, like, for setting after the assessment discharge.
All right, court will set Mr. Jobling for
We want to set it for the February contested docket that gives us about figure out if we can resolve it or. That's the day.
I think y'all can both be ready by February 24th.
I believe.
I-
Mr. White has a sleep.
I'll tell you what, let's, I mean, it's going to be set for a bench trial rather than for docket call, because I think we're past that. So let's just set it for the February 24th. And if you're not ready, then we'll take it up then.
Yes, sir.
So it'll be at 9 a.m. February 24th. You ready on Jordan Manis?
Yes, sir.
Jordan Manis, CR 2397. Mr. Manis is set for pretrial, Mr. White.
Yes, sir. At this time, we don't have any contested pretrial motions. We'll abide by the court's standing order, and ask court to move this over to docket call.
All right, court will place Mr. Manis on the docket for docket call on February 22nd at 9 a.m.
And it's free.
Yes, free to go.
That's all I have, Your Honor.
Yes,
I figure
sir.
you'll be calling Mr. Roberson 3 times at some point.
We will recall him. I'll probably do it at the end of the docket. If he appears, we'll let you know. Ms. Beasley, are you ready?
Yes, Your Honor.
Are you ready on Hannah Hodge?
Yes, Your Honor.
Ms. Hodge, CR 21292. Ms. Hodge, if you'll raise your right hand. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, Your Honor.
All right, you may put your hand down. Is your name Hannah? Is it Nia? Naya Hodge?
Yes, sir.
And Ms. Hodge, are you a United States citizen?
I'm sorry?
Are you a United States citizen?
Yes, sir.
Do you read, write, and speak English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
No, sir.
In this matter, you are represented by your attorney, Ms. Debbie Beasley. Are you pleased with her representation of you?
Yes, Your Honor.
Like you've had enough time to discuss your case with her and have all of your legal questions answered?
Yes, sir.
Is there anything about the paperwork that you've read and signed today that you do not understand?
No, sir.
Ms. Beasley, do you believe Ms. Hodge to be competent today?
Yes, Your Honor.
And you have advised her with regards to her rights and the legality of the pretrial intervention contract?
I have, Your Honor.
Do you believe that she understands all of her rights and the waivers that she's making herein?
I do, Judge. We also went over the paperwork at her last setting in December, as well as discussed them this morning, and both times she's indicated that she understood.
Ms. Hodge, I see that the pretrial intervention contract is regarding the charge of possession of a controlled substance in penalty group 2 less than 1 gram. And that is a state jail felony. If you were convicted of this offense and taken to trial and a sentence was handed down, the range of punishment that sentence would have to fall into would be some period of not less than 6 months or more than 2 years confinement in a state jail felony facility. Do you understand that?
Yes, sir.
Do you understand that if the court approves this pretrial intervention contract, that you would be waiving some important rights today? You understand you'd be waiving your right to a jury trial? You understand that by waiving your right to a jury trial, you're waiving your right to confront the state's witnesses and their evidence in front of a jury?
Yes, sir.
You understand that the right to a jury trial may not be restored to you,
Yes, sir.
meaning that you may not get a chance to do that in the future. If you decide you get into this contract and you don't successfully complete it and you're brought back for trial at that time, you're not going to be able to have the jury trial. You understand that?
Yes, sir.
Has anyone threatened, forced, or pressured you to make you feel like you had to enter into this agreement or waive your right to a jury trial?
No, sir.
Do you understand that you would also be waiving your right to have certain records expunged, meaning that records that the DA's office and the probation office keep on you, you would not be able to have those taken off of your record later if you successfully complete it? Do you understand that?
Yes, sir.
All right, the court's going to find that Ms. Hodge has been admonished of her right to her jury trial, that she's intentionally, knowingly, and voluntarily waived that right. In addition, she has intentionally, knowingly, and voluntarily waived the right to a speedy trial and the limited waiver of expunction. Court hereby approves the placement of Ms. Hodge on the pretrial intervention contract for a period of 18 months. Ms. Hodge, I'm going to ask you at this time, with regards to that charge of possession of a controlled substance in penalty group 2 less than 1 gram, how would you plead to that charge?
Guilty.
And in pleading guilty, are you pleading guilty because you are guilty of committing that crime and for no other reason? You're not just saying that you're guilty so you can get into this program, right?
No, sir.
And has anyone threatened, forced, or pressured you to make you feel like you had to plead guilty?
No, sir.
Court will accept the defendant's plea of guilt, will take that under advisement until the successful or unsuccessful completion of the pretrial intervention contract. So Ms. Hodge, I'm going to have you go ahead and meet with the probation department. So at this time, you can come forward and meet with Ms. Burns, and she'll give you information about the next step. These are all dated December 14th. Maybe just have her date next to it.
Is that all you have, Ms. Beasley?
That is it. Your Honor, may I be
Are you
excused?
sure you're retired?
I'm working on it. I'm getting closer. We do have another one we have to deal with.
Bring her back, everyone. Good.
Thank you, Judge.
Mr. Manning, you ready?
Here, Mr. James Johnson.
James Johnson. CR 21-294. Mr. Johnson set for arraignment on tampering or fabricating with physical evidence, third-degree felony.
Yes, Judge. I've gone over the indictment with my client. His name is spelled correctly. He understands the charge against him, and at this time, his plea is not guilty.
All right, court will enter Mr. Johnson's plea of not guilty into the record. We'll set this matter for pretrial. Can we set it out to a little further than February 22nd? You want something like in March?
That'd be good,
I got
Judge.
March.
I actually received both DVDs, but and they have quite a few files on them. They're not working this time, so I have to work with the DA's office to see if I can get correct copies of them.
About March 8th.
That'll work.
All right, court will set Mr. Johnson then for pretrial March 8th at 9 a.m. Is that all you have, Mr. Manning?
Yes, Judge.
Yes, sir. Good to see you. Mr. Schmidt, you ready? Just have one today also.
Just one this morning.
How did that work out? Good day.
Maybe. It's one way to look at it.
Richard Morrison, CR 21-299. Mr. Morrison is set for docket call.
That's correct, Judge. Today we announced ready for trial. Asked for a special setting in this case.
Ms. Tabrian's going to grab her calendar. So we can see. All right, court will set Mr. Morrison then for jury selection beginning October 3rd. That would be special set number 1. of them all up at the same time. So if you Ashley Smith. Mr. Green, can you see and hear me okay?
Yes, sir. You got
Mr.
me?
Green, can you see and hear me okay?
You hear me now, Judge?
Mr. Green? Can you hear me?
Yes, sir. Can you,
I can't hear
Yeah, I
you
don't-
though.
hang on, I don't know what's up. I can see you. Can you hear me now?
Don't know why I can't hear you. It shows that you're not muted. Say something into your microphone and let me see if it registers here.
Can you hear me now?
Your microphone shows to be registering.
Yeah, I show to be unmuted.
Steve, hang on just a second. Patty, do your office. I want to make sure it may be on my end that we're having a problem. Hang on, Steve, just a second. Patty's going to test something for me. It may be on my end because it shows that you're hooked up.
Your Honor. Can you hear me?
You talking to me?
Your Honor, can you hear me?
Yeah, it's obviously on my end here. You got the problem.
Yeah, I can hear you, Patty.
I'm talking.
Can you hear me, Patty?
Can you hear me now?
Say it again, Patty.
I hear you. You hear me?
Yeah, everybody can hear me, but I can't hear anybody. That's what we're testing. Steve, can you say something now?
Yeah. Can you hear me?
When I unplugged this, I heard her. She came on for just a second, but. Nice pay on this will be. Steve, can you say something for me now?
Yes, sir. I'm here.
All right, try it again.
Okay, I'm here. Hey, Judge.
All right, we're gonna have to go old school. I've got some kind of,
Ooh,
just go ahead and mute yours on that side. There we go. Yeah, just keep your computer muted, and I'm gonna put you on the microphone here. All right, can you see your client? All right, this is cause number CR 21341, Ashley Lene Smith, set for pretrial. Ms. Smith, Mr. Green needs to appear via Zoom today. So you can see him here on the screen, correct? And there on the screen in front of you. All right, any announcement, Mr. Green? No, can you put it up? You have me on speaker. There you go, that's better.
I guess because of the.
I'm sorry, it's not gonna work. Just go ahead and tell me what it is, and I'll stage comes, trust me.
We'll read it.
Okay. All right, Mr. Green said that he expected dismissal and an apology. Mr. Green said that he needs more time to review. He's had to re-access the discovery portal. He's just asking for more time to review the. All right. Mr. Woodwine says on behalf of the state they are unopposed. So Ms. Smith, I'm going to reset you for an additional pretrial hearing. on February 22nd. Do you have any conflicts on the day, Mr. Green? All right, Mr. Green says he has no conflicts and was scheduled to be here anyway on February 22nd. So we're setting Ms. Smith in for February 22nd at 9 a.m. And I'm going to order Ms. Smith to meet with the pretrial supervision office to sign her conditions of pretrial release. Okay. All right. Anything further, Mr. Green? All right. There's nothing further. We'll be adjourned. Sorry for the technical difficulties. Hey, you're welcome. See you. All right, Ms. Smith, I'm going to have you come back and meet with the pretrial release officers. There's going to be conditions of pretrial release for you to sign. That means there's conditions attached to your bond in this case. You're going to have to report, drug test, do those things in order to stay free on bail pending trial. Okay. All right. So come on back here, and Mr. Waddell can give you more information. This issue is. Let's do we have just all right, this is Rebecca Hunter, CR 21387. Ms. Hunter is set for arraignment.
Judge, she is set for arraignment. She's authorized me to formally waive the reading of the indictment in court. We've met out in the hallway. She was just assigned to me this morning. She understands the nature of the allegations against her, that a violation of the health and safety code, specifically possession of methamphetamine less than a gram, that it's alleged to have occurred on May 13th, 2021. She's confirmed that her name has been spelled correctly in the indictment and has authorized me to enter a plea of not guilty, knowing that it's state jail felony, the consequences of felony conviction, etc. So we'd ask the court to reset this for a pretrial.
Remind me what scheduling conflicts you had in March.
Well, the arbitrator moved that special setting to March from February. So I know the court was being extremely gracious of that. So March, now the conflict is 14, 15, 16, 17. So February and late March are open.
What about March 8th?
That's perfect, Judge.
Ms. Hunter, the court's going to set you for pretrial hearing on March 8th at 9 a.m. Once you sign the yellow copy, then I need you to report to pretrial release officers through the store, and they'll give you more information about your conditions of pretrial release. That's fine. Is Laura Fleming here? Laura Fleming? You ready on this, Foley?
Yes, Judge, I am ready on Miss Foley.
Lauren Foley, CR 21262.
Judge, we have an unopposed motion for a mental health evaluation for Miss Foley. And I know we probably could have done it without a court hearing, but the purpose behind that is to ask the court if the court would consider Dr. Compton as a candidate for that evaluation, just simply because I don't want to waste the county's time and resources with a report and then a second request for an evaluation as we've done in other matters.
In other words, you're saying you don't feel confident in the court's psychiatrist or psychologist doctoring.
I don't, not for this particular matter. There's been other clients of mine that he's immediately, and I don't always have to win that issue, but I feel like with particular to Lauren's case and her charges, and of course what I perceive as her inability to meaningfully engage with me as her attorney, I think that Dr. Compton is a better fit for that.
Dr. Compton doesn't volunteer to do competency evaluations down here. She did it in the past. I mean, we asked her to do them here and there, but her practice does not allow her to come down here and do them. I mean, she does it when I ask her to, but she doesn't routinely take business down here.
Understand? I just felt compelled to make the request.
So if Dr. Compton is the one the court would appoint, do you have an objection to Dr. Compton today?
No, Doc, that's the
I'm
request.
sorry, do you have an objection to Dr.
Only in what I've said is that, I'm concerned that there's going to be what we feel like is not a satisfactory effort and then that we're going to be asking the court for the same resources to be directed to Dr. Compton for a second eval, right? And then, so that's another hearing and another delay and things that I would like to avoid.
Is it a male to female issue?
I do actually think it's a male to female issue, and I'm not trying to be sexist, but I just feel like Dr. Compton connects better with women defendants, especially when they're facing what they're presenting with the symptoms they're presenting with, and they're facing the charges that I have two female clients here, and I just feel like Dr. Compton's a better fit.
I'll have to take that under consideration. I don't
Okay.
know if Dr. Compton's willing to be ordered by this court to do anything.
Understood, Judge.
I'll have to ask her. If she says no, then the only other professional that's willing to do it is Dr. Compton, who's conducted competency evaluations and then had second opinions by Dr. Compton. We'll have one here later today where she supports the same findings that he made in another case. So, but you're saying that you believe that you're saying on the record that you believe that Dr. Compton, I'm sorry, that Dr. Ingram does not connect well to females.
He may not.
He may not.
I'm not accusing him. He seems like a fantastic professional. And there are clients that I have had that he has evaluated, and I don't love my evaluator only when they get it right. I just want a good at bat. And that's all I'm asking the court to consider.
I guess I'm confused about what the issue is with Dr. Compton. I mean, Dr. Ingram. Sure. I just don't feel like I'm getting anywhere on what's a good ground to not appoint Dr. Compton.
And Judge,
I mean, Dr. Ingram, I keep on saying Compton.
we know where you're at.
she's easy to do that.
I appreciate it, Your Honor. And then,
Alright, so we'll reset Ms. Foley then, I guess, for docket call on March 8th.
yes, Judge.
I'm sorry, we'll set it for status and docket call.
Yes, Judge.
So Ms. Foley, once you sign this yellow copy with Mr. Ashmore, then you'll be free to go, okay?
Okay, thank you.
All right, Mr. Ashmore, you have anyone else?
I have Miss Fowler.
Grace Fowler, CR 2333, CR 2334. This is the status on the competency evaluation.
Yes, Judge, competency evaluation has occurred with Dr. Compton. We're still awaiting the report. Now that meeting, as I understand it, occurred this month. And I don't know how many meetings it was, but I believe those were scheduled between the 13th and the 17th of this month. So I'm not surprised that we don't have it yet, but I think we'll have it at our next setting.
Grace Fowler's comments. Just got it. She has it. So let me recall your case and we have the.
Okay.
So.
Great.
Ms. Tate Rams.
Great.
Your copy. Ms. Fowler, I'll call you back up in just a moment. You ready on Cody White?
This is the one I needed to visit with you about, Your Honor. He is outside feeling symptomatic. I have not stepped outside to visit with him just yet. I don't know how the court wants us to proceed on that. I know
So he's already coming to the courtroom feeling symptomatic.
No. He somehow or another signaled to one of our deputy sheriffs downstairs. So they have told him to wait outside the courthouse for further instructions from me after I visit with you about how you want him. We need to clear the courtroom out.
We're not gonna do that.
Zoom
I'm
in.
gonna bring him in here if he's feeling symptomatic.
Right,
Can he zoom in?
I will ask him that.
Yeah.
And in fact, we'll make sure he can.
Go see if he can zoom in.
Okay.
If not, then if we can acknowledge that he is here, then
I think
we'll let you announce on pre-trial without him being present.
outstanding. Okay, thanks, Judge. I'm gonna go.
Is Kendrick Willis here? Kendrick Willis? Okay. Just let me know when you're ready for Josh, when I work back in.
I'll get the Zoom info from Miss Patty on the way out.
You ready?
Yes.
Mr. Roberson? William Roberson, CR 21-142, 151. All right, Mr. Roberson, if you'll raise your right hand, sir. Do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you may put your hand down. Mr. Roberson, just make sure you speak up loudly and clearly for me so I can hear you. and so that my court reporter can take down everything you say, okay?
Yes, sir.
Thank you, sir. Your name is William Roberson, is that right?
Yes, sir.
And Mr. Roberson, are you a United States citizen?
Yes, I am.
Do you read, write, and speak English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition? Depression. Are you currently on any type of medication for depression or undergoing treatment for it?
Yes.
Okay. You feel like that medication or treatment is enabling you to have a rational understanding of the proceedings against you?
Yes, sir.
Okay. You don't have cloudy thoughts or confused or anything, right?
Yes, sir.
Okay. In this case, you're represented by your attorney, Mr. Bill Stevens. Are you pleased with his representation of you?
Yes.
Like you've had enough time to discuss the case with him, have all your legal questions answered? Say again?
Now I have, yes.
Now you have. Yeah, is there anything about the paperwork that you've read and signed today that you do not understand?
No.
Mr. Stevens, do you believe Mr. Roberson to be competent today?
Yes, Your Honor, I do.
And you've explained to him his legal rights and also the advantages and disadvantages of a deferred adjudication plea?
I have, Your Honor.
And do you believe he understands those?
Yes, sir, I believe he does.
Mr. Roberson, you are charged by indictment in CR 21142 with a third-degree felony offense of prohibited substance or item in a correctional facility. A third-degree felony in the state of Texas, if convicted and sentenced, carries a range of punishment of no less than 2 years confinement in TDC, nor more than 10 years confinement in TDC, and a fine not to exceed $10,000. Do you understand that full range of punishment?
Yes, sir.
That means that if the court approved the deferred adjudication plea today, if you were placed on that and you subsequently violated that, the court could conduct a hearing. And if the court found based on the evidence that you violated your community supervision, the court could revoke your community supervision, could adjudicate your guilt, convict you, and could assess your sentence in prison anywhere between that 2 years and 10 years.
Yes, sir.
All right. In CR 21151, you're charged by information with a Class B misdemeanor offense of driving while intoxicated. A Class B misdemeanor in the state of Texas carries a range of punishment of confinement in the Van Zandt County Jail up to a maximum of 180 days and a fine of not more than $2,000. Do you understand that full range of punishment? As I'm looking at the paperwork here, I see the agreement is that you're going to plead guilty to each one of these crimes. In regards to the prohibited substance felony crime, the state's recommending that the court not convict you today, that the court place you on deferred adjudication for a period of 5 years, order you to pay a $4,000 fine plus restitution, reimbursement, and the state's agreeing to dismiss some other cases. And then on your DWI case, that you would plead guilty to that, the court would convict you of a Class B misdemeanor driving while intoxicated and would assess your sentence at 1 day confinement in the Van Zandt County Jail, with the court giving you credit for that 1 day of time already served and ordering you to pay a fine and court costs. Is that your understanding of the plea agreement today?
Yes, sir.
And is that what you're asking the court to approve? All right, Mr. Roberson, then to the charge of prohibited substance or item in a correctional facility, how do you plead?
Yes, sir.
To the charge of driving while intoxicated, how do you plead? Are you pleading guilty to each one of those crimes because you have in fact committed each one of those crimes?
Yes.
Has anyone threatened, forced, or pressured you to plead guilty to either crime?
No.
All right, the court will accept the defendant's plea of guilt in each case respectively. Mr. Stevens, any objection to the state's evidence in each case?
No objection.
All right, state's evidence is admitted in each case, and the court does take judicial notice of Mr. Roberson's judicial confession. Anything further from the state?
No, Your Honor.
From the defense?
Rest to close, Your Honor. Ask the court to follow the plea bargain agreement.
Mr. Roberson, do you have any questions at this time?
I just have to worry about as far as work. I mean, that's what my main thing. Like I always show up on my record.
Did you discuss that with Mr.
Well,
Stevens?
we kind of talk, and I'm just, it's gonna show up on there. But I'm wondering, is it gonna allow me, will it disallow me to work? Because that was the main issue for me, is being able to take care of my family, pay these bills.
Yeah, so that's what we call a collateral consequence,
Well, I mean, I follow him now. I mean,
but that's something that Mr.
no,
Stevens,
he's done his job. No, he did right.
so he talked to you about that issue?
Yes.
And so really the answer, I think, to your question is will it allow you to work is going to depend on where you work and what the employer allows or doesn't allow. But it will be on your record. You understand? And so it can't be expunged off your record. It could be non-disclosed off your record, but it can't be expunged.
Well, I'm glad you said that. I've asked people say you get expunged, so that's your answer to that question.
Right. So it's not going to be, it won't be, the only way to be expunged off your record is if you're never prosecuted for it, case is dismissed, or you're tried and acquitted, or you're pardoned by the governor. Okay. But there are non-disclosure laws that would apply to a successful completion of a deferred adjudication, meaning if you do everything that you're supposed to and later your case is dismissed, then you can seek some protection under the law with regards to your criminal record. But it's only in terms of it being non-disclosed to certain agencies. It's not going to be expunged. Okay. All right, Mr. Roberson, I'm going to take a moment and review your case. All right, Mr. Roberson, the court has reviewed the evidence in each one of your cases. The court finds that there is sufficient evidence to convict you. However, the court will follow the plea agreement in each one of your cases with regards to the prohibited substance or item in a correctional facility. The court hereby defers a finding of guilt, places you on deferred community supervision for a period of 5 years, orders you to pay a $4,000 fine, $180 restitution, $360 reimbursement for delinquent pretrial condition fees. Court finds that the state is asking the court to take into consideration DA 2024-17, a possession of controlled substance less than 1 gram, and DA 2024-415, tampering or fabricating with physical evidence. Court also orders you to pay court costs of $290 and reimbursement fees in a total of $1,595. Mr. Roberson, with regards to the driving while intoxicated, the court finds that there is sufficient evidence to convict you of that offense. The court will follow the plea agreement. Court hereby convicts you of Class B misdemeanor offense of driving while intoxicated, assesses your punishment at 1 day confinement in the Van Zandt County Jail, gives you credit for 1 day time served. Court orders you to pay a $100 fine, $270 court cost, and $15 reimbursement fee. All right, Mr. Roberson, the court hereby remands you to the custody of the Van Zandt County Community Supervision and Corrections Department so they can carry out the terms and conditions of the sentence. And have you come forward to be fingerprinted with the deputy. Mr. Stevens, do you have your attorney bill? Yes, sir. So all you have today? You got one.
Set. Set.
Work here. Okay, so yes, I didn't see you on the docket, but it's under Mr. Moore's name.
It is.
All right, this is CR 21250, Richard Sutton. So I'm sitting back there, but here on something.
You know, Mr. Sutton. Oh, you were talking about me.
Take your time. No apologies. Take your time.
Judge, can he sit right here with that?
Absolutely, that's fine. He can sit there. Pull that up there for him. You're very welcome. All right, this is CR 21250, State versus Richard Allen Sutton, set for pretrial.
Set for pretrial, Judge. I'm gonna go by today and pick up videos. We have not obtained the videos across the street yet. So I will pick those up today. If we could reset this for a pretrial sometime in March, we should have some movement on this case by then.
All right, March 8th.
That'll be fine.
All right, court will set Mr. Sutton then for pretrial on March 8th at 9 a.m. Mr. Sutton, once you sign this form with Mr. Waldron and get the yellow copy, you'll be free to go. Okay? And take your time getting out. Make sure you use the elevator at the end of the hall. A lot more busy than you expected.
Happy to see you.
Okay. Mr. Rueda, are you ready? Yes, sir. Noemi Escobar.
Sure.
All right, this is CR 21286, State versus Noemi Leha Escobar. Ms. Escobar, if you'll raise your right hand. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you may put your hand down. Just make sure you speak up loudly and clearly so I can hear you, so the court reporter can take down everything you say, okay? Ms. Escobar, are you a United States citizen?
Yes, sir.
Do you read, write, and speak English?
Yes.
And have you ever been diagnosed with any type of mental condition?
No, sir.
In this case, you are represented by your attorney, Mr. Martin Rueda. Are you pleased with his representation of you?
Yes, sir.
Feel like you've had enough time to discuss your case with him, have all of your legal questions answered?
Yes, sir.
Is there anything about the paperwork that you've read and signed today that you do not understand?
No, sir.
Mr. Rueda, have you explained all of the paperwork, including your client's legal rights to her and the advantages and disadvantages of the deferred adjudication plea?
Yes, Your Honor, I have.
And do you believe that she understands everything?
Yes, Your Honor, she's made it clear that she has.
And do you believe her to be competent today?
I do.
All right, Ms. Escobar, you are charged by indictment with a second-degree felony offense of assault of a peace officer or judge. A second-degree felony offense carries a range of punishment if convicted and sentenced between the minimum 2 years confinement to a maximum 20 years confinement in a prison in the state of Texas. Do you understand that?
Yes, sir.
Also, you can be fined up to a maximum of $10,000. You understand that as well?
Yes, sir.
Ms. Escobar, I see here that the plea agreement is that you're going to plead guilty to that charge, and the state's recommending that a finding of guilt be deferred. That means that you not be convicted here today, but rather you be placed on 3 years community supervision with a fine of $3,500 plus court costs and reimbursement fees. Is that your understanding of the plea agreement?
Yes, sir.
Is that what you're asking the court to approve today?
Yes, sir.
So, Ms. Esquivel, to that charge, how do you plead? Guilty or not guilty?
Guilty.
Are you pleading guilty because you are guilty of committing that crime?
Yes, sir.
Has anyone threatened, forced, or pressured you to plead guilty today?
No, sir.
All right, court will accept the defendant's plea of guilt. Mr. Rueda, any objection to the state's evidence?
No, Your Honor.
State's evidence is admitted, and the court does take judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor, we rest.
From the defense?
Nothing from the defense. We rest in close, Judge.
Take just a moment to review the evidence.
Sure.
All right, the court has reviewed the evidence. I do find that there is enough evidence to convict Ms. Esquivel of this offense. Court will follow the plea agreement. Court hereby defers a finding of guilt, places Ms. Esquivel on 3 years deferred community supervision, orders her to pay a fine of $3,500 and court costs of $290 and reimbursement fees of $35. All right, Ms. Esquivel, you're hereby remanded to the custody of the Van Zandt County Community Supervision and Corrections Department so they carry out the terms and conditions of the sentence. I'm gonna have you come forward to be fingerprinted. After that time, report over here to Officer Burns, and she'll give you additional information, okay?
Okay, thank you.
Thank you, Judge.
Very well. Yes, thank you. Good to see you.
as well.
All right, Mr. Ashmore, can you see and hear me at all?
I sure can, Judge. Can you see us?
Yeah, hang on. I'm having a. Can you go ahead and unmute yourself?
I just had it muted because of the tractor
I
trailer,
can hear you.
Judge. This is Cody. Cody, take your mask off. Cody White.
All right, that's fine. Mr. Ashmore, if you want to come back to the courtroom, if you want to come back in here, then you can make your announcement here because I can't hear anything out there. And then he can just, if he wants to just stay on Zoom, then he can be a part of the hearing that way. I can't hear you, Mr. Ashmore.
I'll be right up there. Just a moment, Judge.
She's out in the hallway. Mitch Adams is her attorney, and we got to coordinate for it.
Not yet.
I know. I don't want to come back out of work, but they just send her on the way.
Yeah, I think we're gonna set for.
Okay. May I send her on her way then? I'll ask. I don't think they want this. Okay, I'll ask before I send her away.
All right, Mr. White, are you ready while we're waiting? I think Mr. Ashmore's on his way up, but we'll go ahead and call your case.
All right.
Who do you want to go on first?
Alphabetical order, Scott.
Robert Michael Schultz, CR 21310.
Your Honor, this is pre-trial. Oh, well, I guess better let him get up here.
All right, yes, this is set for pretrial. Go ahead.
I have no opposition to the motion. There are no motions filed in this particular case at this time right here. We do have 3 DVDs that the state has told them to get them copied off, and I'll be getting those tomorrow, this afternoon. If I could have another pretrial resetting so that I have a chance to look at the 3 DVDs before I completely file all conceivable motions, but the three that I filed, there's the normal file. I don't believe the state would be opposed to them, but I haven't filed those yet. Wanting to look at the DVDs first.
Any objection from the state?
No, Your Honor, I just locally have not made, I instructed my office to make copies for Mr. White. Right now, they're being copied right now, they should be available within.
All right, court will reset Mr. Schultz then for additional pretrial setting. Be available on March 8th.
Don't believe there'll be any problem. March 8th be great.
March 8th at 9 a.m. That's audio problem. We may have a fix. I don't know. We'll find out here in a second.
Whatever we need to do with that. I'm trying to keep it on mute because every time a tractor goes by, it's.
Mr. Schultz, court shows that I have a warrant for your arrest for assault, family violence, misdemeanor. It's not out of this court. It's another warrant out of another agency. I'm not even sure it's this county, but I do show that we have an active warrant for you. So the deputy's going to take into custody at this time. I just have assault, class A, family violence. All right, Mr. Ashmore, are you ready on why?
I am, Judge.
All right, this is cause number CR 21346, State versus Cody DY. Court acknowledges that Mr. White is present. He's not in the courtroom. He's appearing outside the courtroom due to potential symptoms, and so the court's going to allow him to appear via Zoom, and we're set for pretrial. Go ahead, Mr. Ashmore.
Judge, we are set for pretrial. We have an offer from the state. Deferred 3 years or some sort of 1244 reduction with county time offer. I visited with my client. We got this offer today. Mr. White would like the opportunity to go on deferred. This is his first offense, so he's asking the court to reset us for docket call so we can get our plea paperwork ready to go and be back here with time for him to clear up whether this is the crud or the virus and come back to plea honor before March 8th, Your Honor.
Any objection from the state? No. All right, court will set then Mr. White for docket call on March 8th,
Yes, Judge.
9 a.m.
Judge, would you mind telling Mr. Craddock and Mr. White that they're excused? Or I can run out.
Yes.
It might be easier to.
Mr. Craddock, Mr. White, you're free to go.
I need to see.
Your Honor. See how these symptomatic outside.
I'll ask which one to wait.
Mr. Craddock, if you can, I think he just logged off, so you're gonna have to listen.
All right, we're good.
All right, Mr. White, are you ready to? Aaron White, CR 21345. All right, Mr. Aaron White is set for pretrial today.
That's correct, Your Honor. The state has no opposition to the 3 cases that we filed. This case also, I have not received my DVDs. This one's more on me though than anything else. They had them ready last week. They probably attempted to send me an email. We have changed over our email system over at the office. In all honesty, I can't hardly even figure out how to fax anything anymore right now. So that was definitely on me. I just didn't know it was prepared.
Any objection to resetting to March 8th? No. All right, court will reset Aaron White to March 8th at 9 a.m. Mr. White, once you sign with attorney, Mr. White, then and you get the yellow copy, then I need you to report to pretrial services. There's going to be conditions of pretrial release that you have to sign. Okay?
Okay, that's all I have, Your Honor.
Yes, thank you, Mr. White. Good morning, Mr. Steele. Can you see and hear me okay?
Good morning, Judge. Yes, I can. Thank you.
Hey, I called Joshua Flores earlier and he wasn't here. Is Joshua Flores here?
I think he might have got there at 9:10, Judge.
Yeah, he's here now. Come on up, Mr. Flores. Yeah, I had Mark issue a warrant, but I guess he's here now. So, all right, this is.
He told me to tell y'all that he was running about 10 minutes late, but I mean, y'all were in a hearing, so.
All right. Well, all right, Mr. Flores is set for pretrial.
I'm sorry. Yeah, let me get somewhere people aren't talking, Judge. I'm sorry. Okay. I think that's better.
Mr. Flores is set for pretrial today. Do you have any contested pretrial motions?
I do not, Judge.
Okay. All right. There being no contested pretrial, the court will set Mr. Flores then for docket call. Are you available on February 22nd?
Judge, I do have a bunch of stuff on that day already. What's the date? What's the next date after that?
Let's see. March 8th.
I can do that.
All right. We'll set Mr. Flores then for docket call on March 8th at 9 a.m. And Mr. Flores, let me fill out one of these. I'm happy to sign it. Oh, no, this is from Mr. Steele's warrant. Yes, I changed that setting. So I guess it was unchecked. Mr. Flores, Ms. Tabraham's bringing you a notice here. I need you to sign that. I'm going to give you the yellow copy. Once you get that yellow copy, you're free to go. Thank you, Mr. Steele. I appreciate you, sir.
Thank you, Judge. Have a good day.
You too. See you soon.
Bye-bye.
Sid Hoffpower.
Yes, Your Honor.
Good morning, Ms. Baker. Can you see and hear
Good
me
morning,
okay?
Your Honor. Yes, sir.
Excellent. All right. So I have your client here. This is cause number CR 21327, and we are set for pretrial today. Ms. Baker, are there any contested pretrial motions, motions to quash, motions to suppress that you're wanting to have heard?
No, Your Honor.
Okay. So what I do, Ms. Baker, is if there's no contested pretrial motions, then I just send the case over to a docket call. And that would be the final setting in which I would want to hear whether or not there was going to be some kind of plea agreement. And if there's no plea agreement, then if there's a request for a bench trial or a jury trial. So I usually set them about 30 days out. So are you available on February 22nd?
Just a second. Yes, Your Honor.
Okay, so what I'm going to do is I will set Ms. Hot Power then for docket call on February 22nd at 9 a.m.
Okay.
And I'm also going to order your client to sign her conditions of pretrial release today. So we have conditions of pretrial release that are attached to her bond in this case. It's going to require her to report, drug test, do those things. Okay.
Okay.
So I'm going to have her sign a notice of setting here. We're going to give her a copy of that, and then I'm going to refer her over to my pretrial release officer. Okay.
Okay. Yes, Your Honor.
All right. And so February 22nd at 9 a.m. and we'll see you that day.
Thank you, Your Honor.
Thank you, Ms. Baker. Appreciate you. All right, I need the following people to come forward: Xavier Rojas, Talia Powell, Joseph Simpkins. Y'all can all come right up here. All right. So Miss Barber and also Miss Chester, here you go. Y'all spread out to where y'all can see. There you go. All of your attorneys are either sick with COVID or they've been exposed, they can't be here today. So what I'm going to do is I'm going to reset all of your cases, and the bailiff's going to give you a notice of appearance. And I want you to sign that. We'll give you the yellow copy. We're going to bring you back here in a couple of weeks, give them time to get better. Okay. So they can't be here today. They want me to tell you that. Miss Powell, I showed that you are delinquent on your pretrial release money. So after you sign, I want you to meet with your pretrial release officer and try to make some kind of payment today. Okay. All right. So give the bailiff just a second. This is Miss Powell right here. You go ahead and go through that door and tell them that I told you to come meet with them about your pretrial release money, okay? All of them. And whatever they were set for today, we'll just reset them for that same thing. No, just Miss Powell. Mr. Ross. Here you go. Yes. You know, and you know where the annex is? Yeah, it's right on the other side of the gas station. Use all. Mr. Todd,
Yes, sir.
are you ready on, Ms. Walker?
I am just went to the restroom.
Okay, that's fine. I'll tell you what, let's go ahead and call your other one on Mr. Thomas. We'll
Yes,
make
sir.
that record and that'll give her time maybe.
Yes, sir.
And then I can try to get you out of here. I know you don't want to just hang out today, do you?
Oh,
You just
yeah, I
wanna-
always like being here, that
you just want to hang out, I'll leave you over there.
I appreciate it.
This is cause number CR 21-192, State versus Keith LaTroy Thomas, set for docket call today. I see that Mr. Thomas has tested positive for COVID. He tested positive January 22nd. Court has sufficient confirmation of that. We'll reset docket call.
Thank you, Your Honor.
You have your calendar with you.
I do.
I could bring you back as early as February 10th, February 22nd.
February 10th that's I've got a certification hearing on a capital murder case that day, Judge.
You want to get out of it or?
No, I'm trying to get rid of it. I mean, I'm trying to handle that one.
February 22nd.
22nd. That is 22nd looks good, Judge.
Okay, then we'll set Mr. Thomas then for 9 a.m. on that day for docket call.
Yes, sir.
Still the restroom.
I'm just looking outside.
Ms. Walker, this is CR 21-312. We're set for pretrial, Mr. Todd.
Yeah, yes, we are, Judge. We are still doing some negotiations with respect to getting a plea offer. There's some additional documentation that I actually have, but I was in a few counties yesterday and didn't go back by the office. I'm gonna submit that over to the prosecutor, and I believe I'm asking her to take that into consideration in formulating a plea offer.
No contested pretrial motions.
No, Judge.
Opposed to setting it for docket call on that same 22nd date.
Well, I had talked with Miss, because she had heard a couple of dates earlier, Judge, and it fit in better with her. I think it was a March date that she had.
Got March 8th, but that's going to bring you here.
Well, that's fine. I mean, she pays me, so.
All right. We'll set Ms. Walker then for March 8th for docket call.
Yes, sir.
All right, Ms. Walker, once you sign and get the yellow copy, you're free to go.
I thank the judge.
Yes, yeah. Does he have you doing something for him?
Okay.
Mr. Tira? Tyra, is your client here? I know that we're a little bit early.
She is, sir.
You ready for me to call it? All right. Jamie Johnson, you come forward, cause number CR 21295. Ms. Johnson is set for a pretrial today.
That's my understanding. That's correct, Judge. As the court may be aware, I've recently substituted in on this. I don't have all of the discovery yet. I was going to try to work on that today while I was here. And so that's kind of where I'm at this point.
Any objection to state to reset pretrial for Mr. Tyra?
No.
All right, we'll reset. You have your calendar with you?
I do.
Go ahead, let's look at that. I got a few dates in March. I got March 8th, 10th, 22nd. I know that discovery may be a little thicker on this one than the others.
What was after the 10th, Judge?
22nd. Oh, I'm sorry. Eighth, 10th. No, not March. So I just have 8th and 10th in March. Trial that. So I got 8, 10 in March.
That be in the morning?
It would be in the morning.
Okay. Probably. Looks like the 10th would probably be better.
Do you need it? Do you have other settings and other courts?
I do.
Early.
Um,
We can set any time between 9 and 12. You need to be somewhere else first.
then 9 o'clock would be fine. That would probably be. Yes, 9 o'clock would be fine.
Okay. All right. So Ms. Johnson, we'll set you for a pretrial hearing on March 10th at 9 a.m. So Mr. Tyrod, I don't know if there's a notice of setting form we'll need to have her sign that. She'll get a yellow copy and then the white copy will stay here with the court.
Okay. Thank you.
After you get that yellow copy, you're free to go.
Judge.
She's at 11 o'clock, very last one. It's Tyler T.Y. So. So I'll need Carl to testify.
The ones that mentions, or any of them, need to have pre-trial papers. Maybe not. I don't see any. Yeah, you're good.
Yes. All right, when I call your name, I need you to come forward. Jason Bearden, Hector Hernandez, Layton Housh, Tayamika Johnson, Teresa Villanueva,
She's in the hall. She can't.
Oh, no, didn't leave her, didn't leave her. All right, so your attorney, Mr. Adams, is feeling symptomatic this morning, so he didn't come to court. So what I'm gonna do is I'm gonna reset each one of you until February 10th. We're gonna come back, give them time to be well. So we're gonna have you sign this form. We're gonna give you the yellow copy. I need Mr. Hernandez and Ms. Johnson to meet with Mr. Waddell before you leave. Who is, let's see, who is Hernandez? Hernandez and then Johnson, right? So you two, after you get your yellow copy, just hang out in the hallway for a second. Mr. Waddell wants to talk to you about making payments, because I showed that both of you are delinquent on making payments to your pre-trial release. So talk to him about it. I just showed that you're delinquent. Okay, so what's your name? Your house, or your Bearden? All right, Mr. Bearden, you're free to go. And just have a seat in the hallway, Mr. Waddell, so he'll come talk to you. Same for you, Ms. Johnson. Just hang out in the hallway. He said he'll be with you in just a second, okay? So for the record, CR 21266, top of page 3, Vicky Lover told the pretrial release officer that she was feeling ill, so she stayed out in the hallway, and I think she started feeling ill about the time that I was going to drug test her. So we went ahead and drug tested her, and she was positive for methamphetamine. So we're going to reset her until February 10th, and then we're going to take up that drug test on February 10th. Not taking it up, I mean, we're going to take it into custody. All right, so we're waiting on. I'm going to call to his thing. So you said Kendrick Willis is in jail. Is it like a future or something, you know? Kendrick. Mr. Adrian Crane. Mr. Padron, have you talked to your attorney today? Why don't you step out and give him a call? He said he was going to appear online. I haven't seen him online, so fortunately, you're going to have to sit here until he shows up. So you might want to go call him. Kendall Miller. This is CR 15393. Mr. Miller, you have a motion to revoke file in your case. Are you wanting to hire an attorney?
Yes, sir.
If I give you 30 days, do you believe you could have an attorney hired?
I've recently just laid off, but I can try, sir.
All right, so what I'm gonna do is I'm gonna reset you until February 22nd. And I want you to hire an attorney, if that's what you wanna do, and bring that person back. So I'm gonna have the bailiff have you sign this form right here. Once you sign the yellow copy, you're free to go. Now, I want you to remember, you're still on probation. Just because they filed a motion doesn't mean you don't have to report, you don't have to pay, you continue doing those things, okay?
Yes, sir. I see my probation officer yesterday.
Good,
I'm
excellent.
gonna go see her again right now.
Okay,
So I can get my court date set for the same time I see her.
okay. Jennifer Gonzalez. All right, this is cause number CR 2166. Ms. Gonzalez, have you hired an attorney?
No, sir, I was not able to.
Okay, tell me what you did to try to hire an attorney.
We saved up money, but then we got COVID and that put us back again.
Did you talk to any attorneys?
Yes, we did.
Who did you talk to?
To Mr. Davis,
First name?
John, I think, or James, out of
What?
Longview.
Out of Longview? You just talked to one?
Yes,
Okay, how come you didn't talk to more?
because we were gonna go with him, but then we had to use our money.
So you don't have any money saved up for an attorney?
No, sir, we had to count our change to get here today.
You had to count change to get gas money?
Yes, sir.
How much money did you have saved up for the attorney?
We had 1,500.
Okay, how long is it gonna take you to save up money again to hire an attorney?
I don't know, my boyfriend, he's off work for the entire week. He tested positive on COVID. So that's really gonna set us back. I can go with the court appointed one, or we just have to get caught back up and now they put us behind really bad.
Well, are you asking for a court appointed? Or are you asking to hire your own attorney?
I prefer my own, but I can't give you an exact timeline. Like, I know I asked for a month and we were doing really well with it, and then that happened.
If I give you another 30 days, do you believe that you can hire an attorney?
I believe so.
All right, Ms. Gonzalez, I'm gonna give you another 30 days. This will be the last 30 days I give you because your case can't just stay waiting.
I understand.
Limbo. All right, so I'm gonna reset you to February 22nd at 9 a.m. And Ms. Gonzalez, I need you to come over here and meet with the pretrial release officers so they have additional paperwork for you. Mr. Ashmore, are you ready?
Just ready on last meeting is Ms. Fowler.
Ms. Fowler? All right, so we were set for status today, and I know the court just received this today and provided the copy of the competency report from Dr. Compton to both the state and the defense. Y'all want additional time to review that?
We would respectfully request that, Judge. I've conferred with the attorneys for the state. They're in agreement, or certainly they're not in opposition. So we can visit about what our next steps are, and if we could have a reset to figure that out, maybe March 8th, since that seems to be an available date. We make that request, Judge. Judge Chrissy Fowler is the caregiver and driver. May I visit with her for 1 second? I'm sorry. Judge, Ms. Chrissy Fowler has a major surgery scheduled for March the 2nd. So if we can either go before or some period after, she'll be incapacitated for some period of time in the middle of March. I just don't know if is before even feasible. No. Judge Hall set us for a trial on the 22nd. I don't know if that's gonna go, but he has set that for trial in the 382nd. I'd really rather not. I can be in trouble with one of you at a time, Judge, but not both of you.
So not the 22nd, not the 8th. You're gonna have to tell me.
Okay, Judge.
So that's gonna push you out to April.
Is there, there's nothing else in March?
Trial. Give you a trial. You don't want that date.
Not on this
We
one.
could we could set it on the evidentiary docket, March 31st.
Okay, okay. Thank you, Your Honor. We appreciate that very
All right,
much.
so we'll set it on the evidentiary docket and we'll just, I'll set it for docket call and then whatever y'all want to decide on the compass evaluation, that'll give you time to make your move.
Thank you, Judge.
I need her to report to pretrial release. She didn't report November, December.
Yeah, I see in Dr. Compton's findings that is
Thanks, Judge. Sorry for the delay. Hang on one moment, Judge. I think my Bluetooth is on.
Mr. Crane, can you see and hear me now?
I'm here. Yes, and now I can hear you.
I was muted. My bad. All right, this
Okay, here we go.
this is cause number CR 21336, State versus Carlos David Padron, and he is set for arraignment today. Have you gone over the indictment with your client?
He's aware of everything in the indictment. Yes, sir.
Is his name spelled correctly in the indictment?
I believe so. Yes, sir.
And how does your client wish to enter a plea?
Not guilty at this time, sir.
All right, court will find that Mr. Padron has waived the formal requirements of arraignment. Court will enter his plea of not guilty into the record. Court will set Mr. Padron for pretrial. Are you available on February 22nd, Mr. Crane?
I believe so. Yes, sir.
All right, so I'm going to set you for February 22nd for pretrial at 9 a.m. I'm going to have Mr. Padron sign a notice of appearance. I'm going to give him a copy of that, and he's going to be free to go.
Thanks, sir. I appreciate it.
You're welcome. Have a good day. Mr. Crawford, are you ready? Ms. Newton. All right, this is cause numbers, well, we're just gonna say it like this. This is the state of Texas versus Shelby Diane Newton. She's got multiple cases. I showed that all are still set for pretrial. Well, actually, 2 of them are set for docket call and then 3 of them are set for pretrial. Any announcements, Mr. Crawford?
We're ready for trial.
Okay, so no contested pretrial motions on any cases at this time.
Not at this time, Judge.
Okay. And Mr. Crawford, do you want the court to set all of them for docket call one last time so that y'all can determine if there's going to be any plea negotiations? If there's not, I mean, I can go ahead and set it for trial, but typically what I do is I allow time for pretrial to go to docket call. That way, if there's any negotiations to be had or if there's any final things that y'all are working on to get ready for trial, do you want me to do that, or do you mean just set it for jury selection?
That's fine. Go ahead and set it for me.
Set it for additional docket call?
You don't mind, yes.
Okay. Are you available on February 22nd?
I know I'm not.
What about
Wait a
March?
minute. Sorry. Let me look.
Sure.
February 26th. So on the 22nd, Judge, I'm set for 2, 3, 4, 5, 6, 7 trials. 1 in Waco. The rest of them are in Ellis.
What about March 8th?
I think that's a jury selection day, but I could make it work.
Okay. You want me to set you earlier or later on the 8th? We could set you, 9, 10, or 11, 11:30, something like that.
Let's do 11:30.
All right. All right. Court will set Miss Newton then for docket call in all cases on March 8th. We'll set that at 11:30.
Thank you, Judge.
You're welcome. Have a good day, sir.
Thank you, sir. May I be excused, Judge?
Yes, sir. You may. Thank you.
This morning, I was told to be here at 11, but we'll run over at 9. The rest of it did not want to be in trouble by no means. So on March, should I be here?
Okay, so the reset had 9 o'clock, so that's why I got calendared. So 11:30. Next time 11:30, no problem.
Okay.
All right. Thank you for being here. All right, is Miss Miss Lover, is she still? She's already did it, so let's just go with her. I don't need your yeah, what's the setting on her? She's one of Mitch's, so 210. Yeah. Oh, I'm sorry. I got those flipped. Yes. Villanueva, Lavorne, she did test positive for meth. We sent her because she had. So she'll be taken into custody at a later date.
Okay. And this one in here in a few minutes?
So yeah, no, we're ready for her. Yeah, this one we can wait until I'll take it. Is the Villanueva the mint?
No, sir.
Okay, so I just want to.
She has not been able to
All
use
right.
it.
So she. Miss Villanueva, have you given the urine sample yet? All right, I'm gonna give you about 5 more minutes and then I'm just gonna say it's positive. Okay? We'll give you 5 more minutes to get it done. And if you don't, then I'm just gonna count that as a positive. All right? So go out there and drink some more and be back in here to take your test. I'm sorry, I mixed those two. I mixed those. here. All right, we're back on the record, CR 21-271, State of Texas versus Teresa Ann Villanueva. Ms. Villanueva, as I informed you earlier, Mr. Mitch Adams, your attorney, is sick, and so we're going to reset your case so that he can be here. We're going to reset you until February 10th, and that will be at 9 a.m. I have ordered that you submit to a urinalysis test. I know you're still waiting on that, so this is what we're going to do. I'm going to have the bailiff give you this form. You're going to sign it. We're going to give you the yellow copy. Then I want you to walk with Mr. Waddell over to his office and then just stay there until you give a sample. After you give the sample, then I want you back here at 1:30 in the courtroom. Okay? All right, so sign this form with your reset date, get the yellow copy. Go to Mr. Waddell. So Ms. Villanueva, after you give that sample, then come back to court at 1:30. If you don't get a sample between now and 1:30, then at 1:30, I'm just gonna find that you refused, okay? All right?
Hang on a second, just have a seat. Come back here.
All right, so some names to call. Deputy McLeish. I don't know how to say the first name.
Cespedes?
Yeah, that's what I said. Cespedes? Cespedes?
That's what I said.
Cespedes? Pedro Cespedes. I'm also going to call Ronald Perez. Yes, sir. Leonardo Rosas. Yes, sir. Yes, sir. Do not call Kendrick Willis. He is in our custody in our jail. Okay. Sir. And Lance Robertson. Just call those names for me loud.
She just turned 4.
Her test was when they went to grade sign to get the form to take to school, they said negative. So they're like, you can still feel bad or come back in a few days. Yeah. It's on school. She's texting me this morning. She's like, well, I'm supposed to say this morning. She had a COVID test.
Jimmy Smart.
I didn't realize it was 2 logs. She took it. She said it was she said, oh, I have my first knowledge of that on Thursday. I said, messed up.
All right, those defendants who were not present today, their names were called in the courtroom with no response. Their names have been called loudly, distinctly 3 times in the courthouse with no response. The court hereby issues judgment of nisi for Pedro Cespedes, Reynolds Perez, Leonardo Rosas, Laura Fleming, and Lance Robertson. Court will stand in recess until the 1:30 docket at the